Welcome everybody to this webinar, which has a really fantastic crowd of experts here to guide you through this really important moment in your child's education. So we have with us today Jennifer Wright, who's a solicitor at Rook Irwin Sweeney, who specialise in education law, health and social care law, and the Court of Protection. And we also have Charlie Venter and Tom Brook from Kingston Academy, which has an inclusive ethos and therefore is very experienced at assessing the needs, whether the needs of children can be met through the needs in their EHCP can be met by the Academy. So Charlie is head of school at Kingston Academy. Tom is senior deputy head at Kingston Academy. My name's Emily Foges, and I'm here on behalf of Support Send Kids, which is the charity that brings together lawyers who can explain the law around special educational needs and disabilities with the families at the schools, the families of children who, families and schools and local authorities, in fact, who are supporting children through that transition and through that educational journey. If you haven't already signed up to Support Send Kids, please join on the SSK platform because that's where you can come to get your legal questions answered by pro bono lawyers who give up their expertise to answer your legal questions on the platform. And Rook Irwin Sweeney are an example of the kinds of lawyers who are on there willingly giving their time and expertise. So on the platform, ask your questions about the process if they're not answered on this webinar. Browse through the various guides and questions that have already been asked on there because there's a whole wealth of information. Thank you very much to Charlie, to Jennifer, to Tom for delivering this for us today, and thank you everyone for attending. I will now pass over to the team.
Brilliant. Thank you so much, Emily. That's a really helpful introduction. Just to give everyone an idea of how we're going to run things today, we've got some slides here where we're going to talk you through, from my perspective, a legal point of view, the phase transfer process, and to give you some tips about things to look for. And what's really helpful about having Charlie and Tom here is they'll be able to give you a more practical perspective from their point of view as a school as to some useful things that you can do and look out for. So we're going to sort of bounce between ourselves today as we work through the process. And I can see that some of you have already submitted questions online on the platform. So what I'm going to do is extrapolate some takeaways from those and some points for you to be aware of at the end of the presentation, where we will have a question and answer session. And if you could write questions in the chat, that would be really helpful to us because we can then see what's coming up and obviously address things where appropriate. The slight caveat from me is, of course, I can't give legal advice about individual cases, but I will try and draw general learnings that are applicable to everyone out of things that I see cropping up. Perfect. So what I'm going to do is you should hopefully all be able to see the slides that are on my screen here, and I will flick onto the next slide just to explain the things we're going to talk about today. So firstly, we're going to look at what is a phase transfer. We're going to talk about the statutory timeframes that apply to the phase transfer process. And we're going to focus on discussion about the annual review meeting, which is a key part of the phase transfer process. And Charlie and Tom have some helpful insight here to bring in terms of what works best from the school's point of view, how you can prepare for the meeting, conduct the meeting, and the crucial things that you need to do to follow up after the meeting. I'll then go ahead and explain from a legal point of view some of the routes that you can take if you're unhappy with the placement that ultimately gets named for your child to attend. And we'll finish with question and answers at the end. I can see that someone's already asking if the slides will be provided. Just to reassure you, we're actually taking a recording of this meeting, which is why you're all muted and not showing your faces. So that recording will be available afterwards with the Support Send Kids. Moving on to the first slide. So phase transfer is a very specific phrase that we use legally when a child or young person is moving between key phases of their education. Now, it's just crucial to stress here that the phase transfer process is different from the standard admissions process. So what I'm describing today is a process that applies specifically to children with an EHCP. So children who have SEN and support needs but don't have any HCP will follow the standard admissions process. So I'm not focusing on that today. I'm focusing on what happens for the children who have an EHCP. Now, phase transfer applies when a child is moving between any of those settings listed on the slide, but the key ones we're going to talk about with Tom and Charlie helpfully being here are from primary to secondary, and then thinking about secondary on to post-16. Now, you may well be aware that there are specific legal deadlines that apply to phase transfer, and these are particularly helpful because parents and the young person themselves need certainty around what placement they're going to be attending the following September when they're moving from one phase of education to another. So the phase transfer statutory deadlines are in place to help try and give parents, so far as possible, that certainty. And what this means is, as part of the phase transfer process, there needs to be some careful thought about the type of school and the specific school that you might want your child to attend, some consultations to be conducted with the school or schools that you're considering. There then needs to be the annual review that's held. Following in the annual review, where you'll be considering any changes needed to your child's EHC plan and or thinking about the placement you want them to attend, there will be a new HCP issued naming a placement or replacement type that will give you a right of appeal. And so these statutory deadlines exist to help ensure that that whole process can take place, hopefully, in good time, so that if you end up being unhappy with the school named, which we hope you wouldn't be, but it happens, then you have time to challenge that placement and to try and secure an alternative placement. So the statutory deadlines that apply are if your child is moving from early years to school, so infants to juniors, primary to middle, primary to secondary and middle to secondary, that whole process needs to have happened and you need to have an EHCP issued by the 15th of February. So that's fast approaching here. If we're talking about young people who are transferring from secondary to college or a post-16 setting, then we're talking about a deadline for the local authority of the 31st of March. The final deadline that applies is where the young person is going from one post-16 setting to another, and we're talking about that process needing to be completed at least 5 months before the transfer. So those are all statutory deadlines set in law which the local authority needs to follow. Over to you, Charlie and Tom, for a few thoughts from the school's point of view.
I'm just going to start by saying I'm going to say very little. I'm head of school at the Kingston Academy, and we're a highly inclusive school. We have over 55 students who have EHCPs here, but our real expert is Senior Deputy Tom Brook, who has been a SENCO in the past, has responded and considered thousands of consultations, and is also an advisor for the local authority. So Tom is going to really take on the majority of this. So over to you, Tom.
Thanks very much, Charlie. I'll try to provide as much detail for some of these points on the slides here. The first thing, and it may well be something that you have the opportunity to do, I would strongly suggest that when your child is in year 5 and you're thinking about that annual review time, that year 5 review is scheduled in the summer term. Again, I totally understand if you haven't got that opportunity. I say that because when I say autumn term deadlines, Jennifer really helpfully outlined some of the statutory deadlines there. They are the deadlines that are agreed and certainly the local authority need to adhere to by law. The reality is that actually in the background of all the work that goes on between schools and local authority, much of those conversations about whether or not schools are able to meet the needs of a young person are really taking place in the autumn term. I would say that probably about 75% of our placements are agreed somewhat in the autumn term. It won't typically be until the spring term that parents are informed of those kind of firm offers of places in schools. You'll understand that local authorities and schools need that flexibility to have a little bit of window of time to make sure that plans are agreed as they should be, but also it's, some of you will be aware, and some of you may well have experience of this, that there's actually a high correlation of newer EHCPs towards the end of year 6. So there might well be some of you on this webinar now that where your children are actually soon to have an education, health and care plan agreed. So you're navigating that process at the same time as perhaps thinking about applications for school as well. So it's not uncommon for secondary schools to receive later consultations, later applications. And again, that's why I suggest summer term start of those conversations. And it ensures really that there's plenty of time. I know we are in Kingston local authority, and I know that Kingston has deadlines within around about October time, where parents need to indicate the first and usually second or third preferences around the type of school that they're looking for. So there is, this is coming as parents. So my strong advice is to try to start that process, even if you're thinking about having those conversations with your child's primary school SENCO as soon as possible. Second bullet point there, I said ensure that the education, health and care plan is accurate. I know that sounds really trivial. From a secondary school point of view, we probably receive in excess of around 70 consultations every academic year just for year 7 transfer. So quite a lot of consultations to look at. I guess I'm, coming from a school perspective, it's perhaps not surprising that I'm speaking up on behalf of SENCOs. They are incredibly busy people, and I know that you'll have your own personal frustrations perhaps, but experiences, let's say, of the work that you do as parents with school SENCOs, bearing in mind that they're looking at these consultations at the same time as doing their day job, of ensuring that the pupils that are actually in school are, everything is provided for them as outlined in education, health and care plans. The thing that we look for in secondary schools, particularly so, is the outcome section on the education, health and care plan. I would say that's probably the section that I pay most attention to. And it's a phrase I will use probably a number of times. You are the expert in your child. You know your child best. There's lots and lots of professionals that will see paperwork that is linked to your child. They won't know them as well as you. They may never have met them, and they may never meet them. So it's, that annual review time is a really important opportunity for you to look at the outcomes that are on that plan prior to the meeting, and be thinking, is there anything, if the outcomes particularly are not appropriate, secondary schools will be making judgments based on that information. I'll talk about that in the next section as well in some detail. But again, there's never, if you feel that the EHCP has served your child well, and they're meeting some of those things, that's not a bad thing at all. The idea of the education, health and care plan is that it's intended to be iterative and fluid throughout your child's time in school. And if you anticipate some change, start having those early conversations before the phase transfer. I've also said there, consider what you're looking for in terms of the provision that you think needs to be made. It's a really helpful thing to be thinking about. Are you looking for match provision? Are you looking for similar provision that your child's primary school is looking to offer? Or are you, and they are just very simple questions, or are you looking for more support or less support? And I think certainly, prior to phase transfer, that's as much detail as I think that you probably need to approach that time with. But really consider. And I'm not talking about hours of support here necessarily. I'm just talking about the general provision that's in place. If it's something more, then it suggests to me that there's other conversations that need to happen with the school SENCO, with other professionals and so on. And many of you will know sometimes these things take a lot of time. So again, there's never a early enough time to start having these conversations with your child's primary school. I'll talk a little bit more about some of the other points on the bullet point there, because these are continuous processes really, where I've said things like make a list of priorities. I'll come on to that in a little bit more detail on the next slide there. Back to you, Jennifer.
Brilliant. Thank you, Tom. So thinking ahead of the annual review meeting and that preparation that Tom was alluding to there, that's a sort of ongoing process, the number one most important thing you can do is research thoroughly the schools, the school type, if you're not sure, that you think your child might be suitable for. Do as much research as you possibly can, you know, everything on the website. The policies will give you a good idea of the type of school that they are. The Ofsted reports will help guide you as to how large the schools are, what they specialise in. And often we find that parents approach us, might draw up a little shortlist and actually go and visit a school and have a completely different impression, and their preferred choice might change as a result of that visit. So visiting the school in plenty of time and going with that list of priorities or questions to ask them, thinking about your specific child's needs, and thinking in particular, as Tom said, about what they've been getting in their primary school and what's going to change when they move into a secondary setting. There may be children who are thriving in a very small, very nurturing primary school setting, for example, who may struggle in a much bigger secondary school setting where there may be sensory difficulties that arise that haven't arisen in the previous setting. So it's important to think in detail about what it is that's working well in the current setting and what it is that you think your child is going to need going forwards. And I've put some points there in terms of specific things that come up quite often for our clients. So thinking of the curriculum that's on offer, therapies, class sizes, staff to teacher ratios, and then obviously anything specific to your child. It's also key to stress that you can think really broadly in terms of the school choice that you might want your child to go to. You're not limited to specific settings. You can include, for example, consideration of independent settings and those beyond your own borough. There can be some logistical difficulties there, but it's absolutely possible to you to consider all of those types of settings. And in the next slide, I'll go on to explain the legal test a little bit more in relation to those. And try and draw up a shortlist if you can, because the more prepared you can be ahead of the phase transfer annual review meeting, the easier you're essentially making the job of the local authority in the school to talk through those preferences with you and to work out what might be most suitable for your child. And as Tom also said in his talk just then, it's absolutely critical that we're thinking about what's in the EHCP. And it's often a case we find that in primary school, your child can be doing quite well and there may not be that many changes to the EHCP. But when you get to the phase transfer review, it's really critical to be thinking about what changes might be needed. And that might require you to think about also what evidence you might have to support any changes. So while there are therapists who are supporting the child currently, we need to make sure we've got updating evidence from them. Are there any healthcare needs that maybe are developing that need to be taken into account? And if so, have you got any relevant letters from recent hospital appointments that relate to that set those out? So really think broadly about the evidence that's helping to demonstrate the profile of needs that your child has, and making sure that that's all as up to date as possible to help inform those changes to the plan, because that will really help with the phase transfer process when you're narrowing down what schools can meet your child's needs and what provision those schools need to be able to deliver in conjunction with the local authority to make sure that your child's needs are met. Tom, you've got some top tips on preparing as well.
I do, and Arabella has a question about visiting schools and what time to do so. So let me address that first of all. I've said visit schools well in advance. Lots of secondary schools have opportunities, often in the summer term when your child is in year 5, where they might have their open events or open evenings. I know that for children, and particularly I'm thinking of some children with sensory needs and so on, sometimes those evenings can be quite busy. So perhaps make a determination about whether or not you think it's best to bring your child along to those sorts of evenings and events. But it's a surefire way of trying to have the opportunity to visit as many schools as possible. It's important that you get a really good feel for the school and the facilities, because you're kind of doing all the things that every other parent is doing in terms of building that list for what it is that you're looking for at secondary school. You know, every parent is going through that. But then you've got this kind of added priority in terms of ensuring that that their needs will be well met in any school that you're looking for. So I would say seek any opportunity that you can to visit some of those secondary schools. Secondary schools are busy, and again, I'm referring backwards and forwards to some of my thoughts on some of these slides. The reason why I mentioned in that previous slide, thinking about summer term, is because, you know, the autumn term can feel quite truncated. I've talked about having 70 consultations as a school. That's our experience. What we couldn't do is organise 70 separate transition, you know, initial discussions and meetings. That wouldn't, as much as we'd like to be able to do that, that certainly wouldn't be practical for our SENCO to be doing that. And you'd understand that from a parental expectation as well, that, you know, SENCOs can't spend all of their time with parents who are looking around and so on. Some schools operate booking systems, specific dates and tours and those sorts of things. I would be really proactive. Schools that you're showing an interest in early on, I would make contact with them and just find out what their process is. Try to get a visit early on if you can, and then, you know, if you do need to, then book follow-up visits and so on. I think it's very hard to kind of give a very generalised view here, but I mentioned before, think about whether or not it's appropriate for your child to come along to those sorts of visits. I know in an ideal world we'd want to be including our children and young people in all of those discussions. Sometimes those visits can be, you know, quite long. If you've got lots of detail to go into with the school SENCO, and you want to talk about things to the SENCO that perhaps you don't want your child to be aware of, they're just the practicalities. You can always organise follow-up visits if you want your child to come along and visit the school and see things for themselves. So some really kind of finer practical points there. I've talked about that list of priorities already, and I think, you know, really do build that shopping list. Think about what it is that sits at the very top of your list. I can guarantee, having worked in a number of different secondary schools and worked with many parents in this situation, there's no one school that will likely be able to meet everything that you want all of the time, let's say. So I think it's really clear for you to be for you to prioritize and think which schools align with those things that are at the top of that list. I think transition is a very difficult thing, and I think that, you know, some of the best advice I could give you as parents is there will be some bumps along the road, but if you acknowledge that at this early time and understand that and anticipate it, it becomes easier to deal with those things a little bit later on in that timeline there. I've said there, think about short and long term provision, and this links very much to some of the ideas I was talking about around outcomes earlier. None of us have a crystal ball, and as much as I've said that you are experts in your child, you might well, you know, be just getting your head around where your child is at currently, and what it is that they're able to do really, really well and what they find challenging in school. But do kind of challenge yourself and speak to your child and any other support network that you have around you in terms of what you think those realistic expectations are for the end of key stages. So the end of year 9, end of year 11, end of post 16. They can be worrying times. End of year 9, you know, pupils embarking on GCSE choices and so on. I'd be looking keenly, if I was a parent, I'd be thinking about those options and choices when you're having those conversations, because 3 years, year 7, 8, and 9 will go very, very quickly indeed. What you don't want to experience is that you know, your child settles really, really well in year 7, has a great deal of support, and then that in some way is, you know, heavily diluted, or the key stage 4 provision doesn't match your expectations of what you want your child to access and experience. So ultimately, you've got to try to think ahead. You've got to try to think ahead, I would say, certainly in terms of the end of secondary education. What do you think are some of those realistic expectations for your child to achieve at the end of their time in year 11? If that's, you know, a full suite of GCSEs with a view to then going on further, start looking at schools that have that kind of solid foundation of GCSE provision. If it's something more vocational, look for those qualifications as well at that early stage there. Again, all of this said, I caveated this with none of us have a crystal ball, but you do know your child best, and you know it's important that you recognise you're not just making a decision for the first few weeks of September, or or the first year of your child's secondary education. It's got to be a decision that you feel comfortable with, that hopefully is going to make them feel settled and well catered for over the course of 5 years. And the last bullet point I've made there really is in anticipation of any change that you might consider as part of the plan. Really try to maintain contact with your caseworker. Now, I know that lots of us are coming from experience of lots of different local authorities, and there's a lot of change often that parents, when I talk to parents, they tell me that they experience change of caseworker, change of personnel, and so on. Where you can and where that's possible, then really do try to maintain those strong links with your caseworker throughout the whole of that process. Back to you, Jennifer.
Brilliant, thanks. That's really helpful. So thinking then about the annual review meeting itself, I thought it'd just be helpful to remind you here of the relevant legal test in terms of the placements that you can request for your child. As I mentioned earlier, it really can be quite a broad range of placements that you're considering to be named in the EHCP. So you as parents, or the young person where they're 16 or over and have capacity to do so, have a legal right to request a particular school or college is named. And those particular schools or colleges are listed in the Children and Families Act, and they are a maintained school or nursery, an academy, a further education setting post-16, a non-maintained special school, or what we call a Section 41 approved school. So those are some independent special schools that appear on a specific list. And if you're requesting one of those types of schools, there are only 3 reasons why the local authority can refuse that request. The first is where the setting is unsuitable for your child. We don't find this comes up hugely often, but that's perhaps just in the cases that come to us. The 2 exceptions that we find tend to come up more often are where your child's attendance at the school would be what's called incompatible with the provision of efficient education for others. Now, this is most often used where a placement is heavily oversubscribed, but the fact that a placement is oversubscribed in and of itself doesn't make it incompatible. So there needs to be a little bit more consideration here as to how oversubscribed is the placement. Can adjustments be made, for example, so that there would be room for your child to attend? And if your child has a one-to-one, for example, then that means there's 2 people in the classroom additionally as opposed to 1. So there's a series of kind of considerations to be had there. And it's a point to bear in mind when you're going and looking around a school, and if you're asking questions about how many children are on the roll currently, how many children would be in the year group that your child would be going into. So you're already anticipating if there's any potential issue there to consider. The next exception, which the local authority can use, is where the attendance of your child at the school would be incompatible with the efficient use of resources. This is typically used, as I say here, where the local authority considers it would essentially be very expensive to the child to attend, and they think there's an alternative placement where they think the child's needs could be met in that placement and it would be less expensive for them. Now, as I mentioned earlier, you can request a place at a school that doesn't fall within that list, such as an independent mainstream school. And it may be the case that, for example, we have this with some clients where they are more physically disabled, very cognitively able, and an independent mainstream school with very small classes, which is very modern, has great accessibility, may be a suitable placement for you to consider for your child. And you can request that that school placement is considered, excuse me, by the local authority. There's a slightly different legal test that applies, which is that the local authority must only have regard to the general principle that pupils should be educated in accordance with their parents' wishes, so far as that's compatible with the provision of efficient instruction and training, so similar to what I was saying earlier about how your child attending that school would affect others, and also, again, avoidance of unreasonable public expenditure. So you can see the test is similar, but where you're requesting an independent school that doesn't fall on that special Section 41 list, there is a different, slightly lesser duty in terms of the local authority considering your request. So that's kind of the legal test. In terms of the meeting itself, and from a legal point of view, what we find most helpful, I absolutely hear what Tom says about outcomes being really important in terms of thinking about what your child needs to achieve. The sections of the plan that we tend to focus on most of the time are section B. So is that a full and detailed description of all of your child's special educational needs? And if not, which areas are missing, which areas need further evidence or further information to help fully explain your child's needs? And then section F, which is the provision required to meet those needs. So there should be provision to match each and every one of those needs. And if there's not, then it's again worth thinking about where the gaps are. Where is your child likely to need more support? Where are they struggling slightly at the moment? Where would that support be beneficial? So from a legal point of view, we tend to focus on sections B and F in particular. And when we're advising parents, we talk through where changes could be made to boost those sections, because those are also the key sections if you end up at appeal that are legally challengeable. We can't challenge section E, but it is still incredibly important, as Tom says, from the school's point of view. So it's definitely worth discussing. I'll hand over to you, Tom.
Thanks very much, Jennifer. I'm just going to take a moment, just because of the level of detail that might be required for some of these questions, rather than typing. I'm just going to refer to some of these responses here. Natasha and Adrian asked about our son's school do the reviews in January of year 5. You've got some concerns that your son's needs will change in between year 5 and 6. And is there any strategic advice on this? What I would say, and this dovetails really nicely with what Jennifer was saying there, if you feel the needs are might change, it's really important that any kind of assessments that reflect a change in needs are included as part of that paperwork within the annual review and within the timeframes. There's nothing worse, and I've been on the receiving end of this. There's nothing worse than secondary schools receiving out of date paperwork for a child. And I say this with the greatest of respect, because many parents that I speak to, I always acknowledge the fact that as parents, you've gone on a huge journey, often up until the point that you get to secondary age, and it feels like you're constantly kind of fighting, or there's another hurdle or something to prove or evidence. But when we talk, and when I've referenced ensuring that paperwork is up to date, what I find difficult as a secondary colleague is sometimes when parents have a really great desire to almost share that history of their child. It's really important that actually the plan reflects your child as they are now. And sometimes there are things, it's often it happens because people are not necessarily at the local authority level editing plans in the way that they need to. There's really historic information that's in the plans. It might refer to something that happened in year 2 around phonics provision, let's say, or I'm just plucking a type of provision out of thin air there. But if that's still detailed within the plan, the secondary school, obviously not knowing your child, and imagine a situation where, like us, in a school where we might receive up to 70 applications, we might hone in on that particular kind of point, and it might inform the judgment that we make about whether we're able to meet needs or not. So it's as important to make sure that the plan is embellished, let's say, with up-to-date information, as it is to remove any information that is no longer up to date. I think that's really important to share there. I hope, Natasha and Adrian, I've kind of answered your question there, particularly in terms of ensuring that up-to-date evidence and advice from any other external agencies and professionals is certainly included within the kind of update to the plan there, because it sounds like in your case it might well link to a change in the provision that needs to be made for your child. Helen, you've asked about year 8, a situation for your son in year 8. I'm sorry that you're experiencing that, where schools have suggested that they're not able to meet or discuss. What I would say, my advice to you is to contact the local authority in this instance and ensure that they are in a position that they put pressure on schools to enable those visits to take place. Some schools that perhaps don't have so much of an open and inclusive philosophy, do find it difficult to make the time to meet with parents in your situation, but they are obligated to do so. and you know, the local authority can apply that pressure on those schools there. In terms of residential placements, I have some experience of residential placements, but the process is fairly similar in terms of my experience. Often, you know, with residential placements, there are more complex needs for a young person, or sometimes medical needs. So again, it's just ensuring that the residential place and you know, their specialism or where their expertise lies, just think about whether or not that matches the type of provision that you're looking for your particular child there. In terms of all through schools and phase transfer, well, phase transfer is that process in law, but it might be helpful just to check with individual schools to see what their process is. I certainly wouldn't assume that it's you know, natural progression from one key stage into the next, because you know, and there's nothing wrong with just ensuring that that is you know, you check that with the school, because the school may well have ideas, and you know, this alludes to the information that I shared earlier about that kind of 5-year plan. When you're making a choice about secondary, the school may think, actually, we can meet the needs now, but we might not be able to in the long term, and you wouldn't want any embarrassing conversations further down the line. So do check in with the school to see what their process is there. And Fleur, you make a really interesting point there about that the phrase in law around incompatibility with provision. I'm going to touch upon that now a little bit, and I'm going to refer to the arbitrary number of 70 EHCPs that I've said, you know, year on year that we might receive consultations for. In an ideal world, obviously, a school like ours would want to be able to provide for all of those children if we felt that we could meet their needs. The reality, of course, is that you know, if we took all 70 students, that would be almost half of our published admission number for the whole year. And that goes back to the fact that this process of first putting in your preferences to the time that then parents are informed about places being given, there is a little bit of movement. You know, as a school, we almost need to prioritise. When we get education, health and care plans in, we do actually go through a kind of prioritisation process ourselves of saying, well, of these 70, we might definitely be able to meet the needs of, let's say, these 40 students. And then of those 40, these are the students where we feel the quality of our provision best meets the needs of these, you know, these specific 10 children, let's say, because the moment that we start accepting pupils and that's confirmed by the local authority, you can imagine a situation, the more students that any one school admits, you're then in a situation where you might have that question about incompatibility of efficient resources. If you've got, you know, 40 students with high levels of needs in a class, that's a very different situation for a school to manage. They might be able to meet the needs of those pupils as individuals, but you know, if we were to admit all 40 of them, then that would create some challenges for those schools to, you know, maintain smaller class provision, let's say, or the number of hours of TAs that they have across that provision. So I think in summary, what I'm saying there, the greater the need the school has that they've agreed to, the harder it then becomes for a school to say yes. And we can't put a cap on that. You know, no school can turn around and say, look, we've admitted 10% of our overall pupil admission number already, and to admit any more would create X, Y, and Z. But some schools, and I include ourselves in this as well, we have to provide some sort of tentative argument back to the local authority, because I'm sure, you know, if you're a parent and if you heard, you know, that a school that you really liked has offered a place to your child, but then there's 39 other EHCPs in year 7 as well, you might have some different feelings about the quality of the provision that the school is then able to provide, given the sheer numbers of pupils that we're talking about there. So it's never a science, but that's, again, part of the reason why there's a lot of conversation that goes between school and local authority. Again, I say that with the caveat of we'd love to admit all students if we could, but there, you know, I think there is a tension, isn't there, between what the law says and the reality of how many places a school could reasonably offer without that creating some incompatibility for the efficient education of others there. I think, you know, some of the other top tips on that slide there, I've talked to and I've talked about already, but happy if there's any other questions that come through. I'm going to pass back over to Jennifer.
Perfect, thank you, Tom. Just one added point from a kind of legal point of view in respect of that oversubscription question. So in terms of you wanting to name a school that is currently oversubscribed, I think it's just worth pointing out that the local authority does have, in relation to those majority schools that are listed in section 38, does have the ability to order a school to be named, even if the school is saying it thinks it would be incompatible and it's oversubscribed. Now, obviously, as Tom says, there's an inherent tension there, and it's important for you to be considering, you know, can that school actually meet your child's needs if it is so heavily oversubscribed that, you know, you're worried it might not be able to give your child the attention and support that they need. But I just wanted to flag to parents that there is that possibility still of getting that school named, even if it's saying it's oversubscribed. The position's slightly different in relation to independent schools, and I'm just wary of time, so I'm not going to go into detail on that now, but obviously if you have specific questions you can always put them on the Sports Send Kids forum so that we can look at them there. There's one other question to pick up on. So I can see that Matt has just answered it about social care and housing, slight added aspect from a legal point of view, which is when you're considering updates to the EHC plan, it's relevant to consider the social care and the healthcare sections, and if any updates are needed to those, and making sure that those are up to date in reflecting your child's social care needs and any provision required to meet them. Because again, it just helps give a more indicative idea of the overall support that your child needs, particularly if you're thinking about residential placements and so on. Just moving on to the next slide, which I'll briefly go through. So this is just about follow-up steps for you to take after the annual review. I won't go through them in detail because they're listed here, but it's just relevant for you to know, again, that there are statutory deadlines which the local authority has to abide by, and someone's asked about what you do when they don't, and I will go on to that shortly. But essentially, the local authority after the meeting needs to tell you that it's hopefully going to update the plan. It needs to do so within 4 weeks. It needs to provide you with the updated plan showing the amendments. It's no longer enough to just tell you it's going to update the plan. There's helpful case law that we've had on that recently. They need to send you that draft updated plan, and then you get 15 days to look over it to see if there are any other changes that need to be made or any changes that you disagree with. And again, you can confirm your placement. And then there's that hard stop deadline within which the local authority needs to finalise and issue that amended plan. And that's crucial because once you have that final amended plan, if you're unhappy with the placement or the placement type named, because the local authority can simply name a type if there's not a specific school identified yet, then you get that appeal right at that point. Just pass on to you, Tom, quickly.
Yes, I'm not going to elaborate too much on the points there. The key thing I've said is that ensure that you're meeting all of the deadlines that you need to as well. If you're asked to do something by either the school or the local authority, just ensure that none of the delays are down to you unless you can't help that and you're waiting for information from somebody else.
I'm just going to briefly now talk you through a couple of remedies and routes available to you if you find at the end of that process that you are unfortunately unhappy with the ultimate placement named, or if you're finding that your local authority is delaying in not meeting those statutory deadlines and it's not yet named a placement or type for your child to attend. So the first option available to you is to submit a complaint. This you can do without legal assistance. I've put a link there to a template. It's a helpful process in that it obviously draws it to the local authority's attention, but as I'll go on to explain in the following slides, it's also potentially a bit of a time sort of laborious process, and you may in fact want to go to one of the following methods, which can be slightly quicker and punchier in their legal effect, essentially. So the second option available to you is to send something called a letter before action prior to judicial review. And you would send this to the local authority, and you can get a lawyer to help you with this. And essentially, you are challenging the local authority for failing to meet whichever relevant statutory deadline it is. And it's likely to be the breach of Regulation 18, which is the helpful regulation that sets out the relevant timeframes within which the local authority has to complete the process. And the reason why this can be beneficial over a complaint is that it goes to the legal department of your local authority, and they're required to reply within 14 days. So it can get them to sit up and listen and to make sure that they're taking the steps that they need to move things forward. The third option is you can consider mediation with the local authority. Typically, we find that mediation is most successful when parents and a local authority are quite close on an issue. So it's more often effective where, for example, there's a disagreement about the number of hours of speech and language therapy that your child requires, for example, where there's a big dispute about placement. So you are substantially choosing a different placement to that which the local authority has named. We can find it's less effective because you're less likely to reach agreement. And again, thinking about timings, it can take a little bit of time to set up that meeting. You may prefer instead, given there's limited time to get an appeal issued if you're unhappy with the placement, to just crack on with getting an appeal issued. But I just wanted to flag it's a possibility. If you've got an incredibly organised school and local authority that have held a really early phase transfer annual review meeting and you've got a decision early, then it may be something you can consider. And the final option, which is the most common one, is appealing to the Senate Tribunal. And there's a specific deadline within which you'd need to issue an appeal, but essentially you'd want to get on and issue an appeal as soon as possible, because we're finding the tribunal is incredibly busy and there are more and more appeals being brought to it currently. So if you're clear that you're unhappy, don't delay, gather the evidence and get on with issuing an appeal. I wanted to flag that you can still get legal aid to carry out Senate Tribunal appeals. It's a specific limited type of legal aid, so it helps you throughout the appeal process if you're eligible, but it doesn't include provision of advocacy at the hearing itself. So either you will need to do that or pay someone or find someone pro bono to support you with the actual hearing if it gets to that. And I've put there whose means the eligibility is based on. It's worth flagging that the majority of appeals are still settled in favour of parents. So the latest statistics from December 2023 found that 98% of parents who went to tribunal won on appeal. So it is an incredibly successful, helpful route for most parents to help them to try and secure the placement that they need. Now, that statistic obviously doesn't talk about where cases are settled or withdrawn in the lead up to the final hearing. And that does happen. You may reach agreement with the local authority, or you may decide that you actually ultimately want to try the school name, for example, see how that goes, and then move things forwards from there. But it remains a really helpful route. It's accessible to parents. It's meant to be an accessible, sort of friendly forum. So it's completely possible for parents to run appeals on their own, and they often do, or they can get legal support to do so. The final slide I just wanted to flag, which has actually come up in some of the questions that were submitted beforehand, was what you do if your child's moved to the new school and then things start breaking down. So the first thing I wanted to flag is really if there's key provision from Section F that's not being put in place, then obviously have a conversation with the school first and foremost. You know, is it a case there's been a miscommunication? Is it just that the child's moved, they've not yet had the chance to set up the speech and language because the therapist has just left and they're finding a new one? You know, find out what's going on. But it's crucial to remember that the actual legal duty for delivering everything in Section F lies with the local authority. So even though the schools often in practice arrange a lot of the provision, the local authority has the legal duty. So if something's not being provided, they are the person who has responsibility. And so what you could do is consider sending a letter before action, as I mentioned earlier on, to make sure that that provision is being delivered and secured. And if there's a reason, for example, you know, they can't find a statutory physiotherapist to deliver it, then a private therapist could be employed by the local authority to deliver it. So there are creative workarounds that we see happening all the time at the moment, but that's your sort of best route of remedy there. If you're finding ultimately, though, it's not a question of provision, it's a question of the placement as a whole not being able to meet the need, then it's absolutely possible to request that the local authority arranges what we call an urgent or an emergency annual review meeting to discuss a change of placement with the school. And if it's got to that point, it's probably quite likely the school are on board and sort of, you know, you won't have taken that decision lightly. And they'll be able to help guide you and the local authority as to what may be a better, possibly more suitable placement. And again, you can request any of the placements that I mentioned earlier. Someone in one of their questions, which I just want to touch on, that they submitted in advance, was talking about what you do if your child has a placement breaking down, they've got SEN, but they don't yet have any HCP. There's a couple of things you can do, but I wanted to flag to that parent that you mentioned your child's not yet been assessed for any HCP. You can, as a parent, start the EHC needs assessment process yourself. You can submit evidence, you can do it with the school or you can do it on your own, but it can be a really helpful way to get obviously a plan in place, which then means you've got a provision in place to help support your child to also think about specialist placements. And it's just a key thing to think about if your child does have SEN, you've not got a plan in place, consider if you need to be making a needs assessment to help support them in their change of placement. That was a whistle-stop tour. We've got some key takeaways for you. So the first one is obviously prepare. As Tom and I have said, the more research you can do, the more investigation, the more you can think about what your child would most benefit from, the better prepared you'll be to present your case, essentially, and the easier you're making it for the local authority, hopefully, to agree with you. Also, make sure you've got those statutory deadlines diarised. It's really important, and it will help you to keep on top of making sure things are moving forwards, but also you've got enough time to then appeal if you need to issue an appeal. I've put a link there, a hyperlink. When we circulate the slides, you'll get it. So the Noddy No Nonsense Guide. It's a really brilliant resource. We use it all the time. Parents we support use it all the time. And it sets out key law and case law on all of these key issues relating to children with SEN and their education. So do have a look at that and use it. So make sure your SENCO is aware of your thoughts well ahead of transfer. Discuss it with them, get their advice, get their guidance. They will know your child, they'll be working with them, they'll understand what they need on a daily basis. And then, yeah, the more you see, the more informed you are, the better it will help shape your preference if you're able to visit settings, if you're able to talk to parents, the more you can read online about the schools and use those legal mechanisms available to you if you need to, if and when something goes wrong. I know we've dealt with some questions already. I'm aware we've got limited time. There were just two other quick points, I think, that were in questions submitted beforehand, if I can just briefly address those. One was a question in relation to a child where there is a placement breakdown in the middle of the placement. So I just wanted to flag, as per my kind of penultimate slide, speak to the school. You can call an emergency annual review. That is a helpful process if you're in the middle of a placement and things are just not working. And you can consider things that aren't placements. So you can consider something called education otherwise than at school if you're finding that not only the placement isn't working, but also you think any placement would be unsuitable for your child. There are creative options available to you to think about in terms of your child's education. And the final point was just about that education otherwise than at school. So when that's specified in a plan, then it's something that the local authority needs to fund. So it's a formal special educational package made under an EHCP for which the local authority remains legally responsible. And it's different to elective home education. If you just choose to home educate your child where there's no local authority funding, the local authority has no obligation to deliver the provision set out in Section F. So there's just an important distinction I wanted to draw there, linked to that question that someone was making. I think that's everything from me. I haven't had a chance to see the last couple of questions come in, but I'll just have a look at them now. I don't know, Tom, if you have any final thoughts.
I was just typing a response to that last question that I've just seen come through. If you're in that lovely position of not being able to decide between two schools in which to target, I'd say think about the relationships that exist already between your child's primary and secondary school. It might be that there's more pupils that have that history of transferring from your child's current school to the secondary, and therefore there's a hopefully a kind of more I guess a wealth of experience of how transitions work between the primary and secondary school, because they'll have gone through that process hopefully many times, and it will be a well-trodden path for that primary and secondary.
Brilliant. I think we've managed that pretty much within an hour, so we've stuck to time mostly. Emily, did you have any final thoughts?
Wow, thank you so much for cramming a huge amount of vital information into an hour for really a really good audience that we've got today. So thank you to all the participants for all of your really sensible questions, that's been really excellent. Just a quick reminder of those key deadlines coming up. So 15th of February for secondary transfer, post 16, 31st of March. Make sure you're prepared, do loads of research. In my experience, that includes visiting schools that you know aren't appropriate for your child, because that helps arm you with information to explain why that's not right when the local authority names them. Gather, and anything could be evidence. I'm always surprised at what turns out to be evidence once you need it. All doctor's letters, all appointment letters, all school reports, keep it all neatly filed if you possibly can. I think really great tip there from Tom was really sort of rang through for me, was making sure your EHCP is up to date includes taking stuff out. Because the stuff that you've left in, because you're snowblind and you've looked at it so many times, might be the thing that the decision hinges on, and that would be a shame after all the effort that you've gone to. Thank you very much, everybody. And a reminder, please, join the SSK platform, log in, log your questions, browse through, look at the guides. We'll help you understand what the law means to your child or the child that you're supporting through the process. Have a great afternoon.
Everyone.
Thanks, everybody.